of going to college like regular 19-year-olds, he was going to prison. Instead of learning how to become a productive citizen, he was learning the ways of prisoners in our jail. So think about the fact that even now, in these difficult economic times, when Mr. White goes to compete with the 8.5% of the people who are unemployed in this state, he has to show a letter that says, I was wrongfully convicted and I was exonerated because of DNA evidence. And just think about how that hampers his ability to operate in this economic climate, because there are so many people who are out there looking for work. If you look on television, every time there's a job fair, people are lined up all around the buildings looking for work. And think about going into that line, and you got to take this letter that says, look at me. And you got to explain what has happened to you. So, of course, as a state, we can't give him back his youth.
Okay. Representative Hugo, I think we've got a question here from
Okay, I'll
Chairman
be glad
Smith.
to take questions.
Okay.
Representative, you had mentioned that there were some other crimes that he pleaded guilty to at the same time this occurred. What was the sentence for those if you just pulled out the rape charge?
If the rape charge, if the only thing that he was, other than the rape, the robbery, and the aggravated assault, was all one occurrence.
Okay, so there wasn't anything else. That was the reason he was arrested. But what was this business about a convenience store?
The burglary of the convenience store was the initial warrant. And after he was sentenced to life for those others, his attorney told him to go ahead and plead guilty. His mom and dad were paying for his defense. And so he pled guilty. But think about the fact, and in the court documents, it says he was given 20 years for that. But if you think about it, a 19-year-old with no prior convictions would not get 20 years without these other circumstances for burglary.
What kind of, for the convenience store that he pleaded guilty to, what would have been a normal sentence for that time for a first-time offender?
This is Mr. Dowdell. Come on up here, Mr. Dowdell. And he's Mr. White's attorney, and he can answer these legal questions better than I can. So I'm going to ask him to come up. But for other people, the person who was responsible, James Parham, the person that I showed you, that was the actual responsible for the rape, got 3 years for burglary at around the same time in that same county. So I would say that would be a reasonable estimate of what you could have expected him to have gotten.
Why don't you let the attorney speak? That would probably be helpful to us.
To the chairman and the committee, thank you for allowing me this opportunity.
Will you identify yourself, please?
Yes, sir. My name is Attorney Darrell Dowdell.
If you'll pull the mic down, too, please.
Yes, Attorney Darrell Dowdell. I had submitted a letter to the chairperson in the committee. I also have Mr. White chronology if members of the committee need one while we're speaking on these different dates.
Sure.
These circumstances. Mike. Chairman in the committee, I have attachment 4 in the letter that I submitted to you on March the 5th. Attachment 4 letter has a conviction of James Parham of burglary during the same time Mr. White pleaded guilty of a burglary charge. James only received 3 years, notwithstanding the fact that he had a large and long criminal record. I said all that to say this. Mr. White probably would have received probation. I've been practicing law now for about a little over 18 years. I used to be assistant DA. I tried everything but a death penalty case. That burglary charge was not the reason why Mr. White spent over a decade initially in prison. It was because of the wrongful conviction of the Marietta County jury led by the hem of the district attorney's office.
Can I stop you right there just for a
Yes,
second?
sir.
The lineup, how was he chosen in the lineup?
Well,
Was he an acquaintance of the person that ended up actually doing the rape?
no, sir. The way it normally works, you have either the GBI in concert with the DA's office, the police department, all three in concert would give a victim a book of photographs
Right.
of the height, the race, the gender, the build, and they would come up with these different compositely different pictures.
Right.
And they also look at those persons in that same area that are already accused of crime.
Okay. Let me
So-
stop you right. Did he know the individual that ended up being charged with the rape?
Yes. I mean, he didn't know
Was
him.
Was he a friend of him?
No. I understand they were not friends, but in Meriwether County, everybody know everybody.
Sure.
But what's so interesting about this, we believe if you look at that photo lineup, the real culprit was twice as size and weight, different complexion. Mr. White at that time was wearing what we call an afro. I mean, they wear them now. So they were not even similar in terms of physical characteristic. We believe what happened when Mr. White was apprehended, his driver license was confiscated. Excuse me. When his driver license was given from his person to the police department, the GBI, and the district attorney's office, we believe that driver license was used in ways to somewhat either suggest or to help aid a eyewitness.
Can I stop you? Let me ask one other question. Was that before the pictures were on the driver's license or afterwards?
The picture was on the driver's license, Mr. White. Yes, sir.
Okay. All right, let me stop you. Got a question here from Chairman Williams here.
Yes.
Question to the attorney. He served 10 years on the original charge of rape and was paroled in 1990. Is that correct?
Yes, sir.
Okay. Once he was paroled, had he not done any of these other things, he would have still been a free man. He would not have to go back to prison if he'd had his record clean. Is that right?
That is correct.
Okay.
Can I just add, when you get out on either probation or parole, you have to report to a parole or probation officer, which require you to get employment. If you're not legally employed, they can also say that is a violation of your parole. This is similar because Mr. White was given an ability to swim, but he had both hands tied behind his back and thrown in the ocean. He was a statewide registered sex offender of a brutal and an unimaginable crime against a 74-year-old Caucasian woman in Manchester. There's no way or any reasonable opportunity he had for legal employment. It's just not realistic based on the crime that was allegedly committed by Mr. White and convicted by a jury of locals in Manchester, Georgia.
Stop. We got another question here from Chairman Smith.
This also is for the attorney, but on this document that you passed out on March 14th, 94, the reason he was put back in jail was because of the possession of cocaine. Is that correct?
That is correct.
Now, that's a personal choice, not necessarily a life and where you've got to eat or something along this line. Cocaine is a choice that you make that you don't have to do.
Yes, sir. We have been straightforward with the currents of event that transpired in Mr. White's life, but we also just asked the committee to at least look at what we call, in legal terms, the totality of the circumstances. If you've been incarcerated 10 years and 10 months, rape is a different kind of crime. Even criminals have code of ethics. And one of the code of ethics, if you're in jail for being a pedophile or raping an elderly woman, there's a high probability you're going to be not only mentally assaulted, but physically abused. It's not called rape, because rape have to be with a female or male sexual organ penetrating. But it's the same different. It's the same brutal physical violation of your body that this man, Mr. White, had endured in prison for 10 years and 10 months. So I do understand he had personal responsibility and made personal choices. But I'll ask the committee to at least look at the total person as opposed to in isolation.
Thanks.
Continue on. Wait a minute, we got another question here, Chairman Williams.
Can you tell me, he was paroled in 1990, and it was 2004 before he asked for the Innocent Project to test for DNA. Why did he wait that long?
Well, he got out in 1996, and he was actually in 1996 he was released from prison after serving 2 years for the cocaine. In 1998, July the 1st, and it's in the chronology that Mr. White pleaded guilty to a robbery and was sentenced to 7 years in prison. So that was a time frame that he was incarcerated as well, and that was 7 years. After that 7 years was completed, he was actually serving time again for the wrongful conviction of the rape that occurred in 1979, 1980. So he was actually, his person was brought back to the prison system, and after he finished the 7-year sentence, the last 2 years and 3 months, he was serving strictly and only on the wrongful conviction that went back to 1979 when he was arrested.
The Innocence Project had not been in place since 1979.
When did it come in place?
DNA evidence is something recent. So
Well-
he could not have asked for it, before the Innocence Project became available. And of course, he asked for it when it became known to him. After he received notification that the Innocence Project was out there and available, then he wrote to them and asked them to take on his case. So when he became knowledgeable of the Innocence Project and what it was doing, then he asked them for their assistance.
When was that known?
It was in 2004. What I want
Is
to
that the first time that,
Yeah.
that DNA was ever?
No, this is the first time, Mr. White. What is so interesting about this case, I think the committee might want to know this for some form of reference point. In December 2004, Mr. White, like the representative said, didn't have any knowledge of the Georgia Innocence Project. But when the Georgia Innocence Project sent not only Mr. White, they sent out 1,400 pamphlets to all rape conviction prisoners in the state of Georgia. 1,400. Out of 1,400, only 2 responded, said that they know for a fact they was wrongfully convicted, and if they had a chance to explore this DNA process, that the physical evidence science going to clear. It was Mr. Williams and Mr. White. The rest of the 1,400 minus 2 did not respond, which you can draw a deduction or a conclusion that they believe that once they test hair follicles or saliva or tissue or whatever type of physical evidence, that they are going to be in fact considered guilty by science. Mr. White, Mr. Williams, they responded and said, look, please, Georgia Innocence Project. I think that time Amy Maxwell and still now is the director. But Mr. White and Mr. Williams responded. And that was the first opportunity he had to respond through another agency to fight for his freedom. And he did that quite timely.
Okay, let me stop you 1 second. Chairman Parson has a question for you.
Thank you, Chairman. There's a couple of questions. Line 12 and 13 of the substitute House Resolution 161 says that the indictment was no prost, which means I believe that the prosecutors actually went to the court and submitted that the wrong person was prosecuted. I mean, is that correct?
Yes, sir, that's correct.
They requested that prosecution be basically null and voided. Is that correct?
Yes, sir. Like it never existed. That's correct.
Okay. Second question. I know I've been through these a few times over the last 2 years. I may be not seeing somebody out there, but I know normally the Innocence Project people who have been involved in these come. Is anybody here from that organization today?
I'm not aware of anybody.
I mean, normally they have come and they have testified that was the case, that they've been involved. Now, okay. I mean, I'm just curious why they're not here and anybody is not here from the Innocence Project. Not necessarily that I would give it more credence or less credence, but I'm just interested why they were not here. Okay, so they're in process. And then the third thing, I actually had the honor of chairing this subcommittee for 4 years, and I know during that time, one thing I always tried to keep in mind was that we're not the jury. We're not part of the judicial process that found him guilty back in those days. But I would like to ask, and I know that we really, I think we have the right to look at anything, even though we're not part of the judicial. I'd just like to ask either of you, since you had mentioned, the attorney, that there was such a large physical difference between this gentleman and the gentleman that was found to be the perpetrator. Just curious, how do you think that the victim could have made such a mistake, since there was a difference physically in the two, and she actually identified that person? Here again, I know we're not part of the judiciary, we're not part of the court system that found him guilty, but I'm just curious, how could she have made such a mistake?
Well, we believe she was actually following the direction of the police department, the GBI, and the district attorney's office. When I was assistant DA, even when we take a case before the grand jury would indict you if you tell the grand jury out of 28 people that make up the grand jury proceeding, if 13 vote that is probable cause to take this before the jury, if the DA or assistant DA tell the grand jurors, locals, residents, they would do it. So she basically allowed the DA office, the district attorney's office, the police department, in concert with the GBI. And we believe that Mr. White's driver's license, which clearly had his picture, his face on it, we believe that that house was transferred to Mrs. Neely, who was 74 years old at the time. She was beaten so severely, part of her face was paralyzed. It actually happened around 4 o'clock in the morning. So we believe she had no reasonable chance of identifying Mr. White as opposed to anybody else in that lineup. We believe that it was suggestive. I mean, the case is very old, so it's not probable that I can come back with an eyewitness before this committee and say, look, do an affidavit or testify to this committee that you actually did that. You took his driver's license and gave it to and showed it to Ms. Neely, who thereafter picked him out instead of the real culprit, which was a body in between them. You know, she could have easily just moved down one body, then two, and picked out the person who actually committed that horrible crime. She didn't, because she was actually led by the state. Now, we do believe that she believed in her heart that she picked out the right person. We believe that she relied, like all victims do, they rely on the state to prosecute alleged aggressors of crime. We believe that she relied on the state. Okay. That's why she picked him out.
And just one more, if I may, Mr. Chairman. So then the prosecutors, because they did go through the process of the no process of this case, they have said that they thought they made a mistake.
Yes, sir. As a matter of fact, if you look at specific dates, September 28, 1979, the police did a lineup. I'm on the chronology.
Okay.
September 28, 1979, it was not Miss Neely that actually led the prosecution. She was just the innocent victim. She relied on the state. In September 28, 1979, the state, along with the police, did the lineup we just talked about. And also, on November 19, 1979, the state asked for what we call a true bill, an indictment. That's mean when you formally charge, you can be arrested and then released. He was formally charged under the direction and the control of the district attorney's office, which asked for a true bill, and they received it. You ask for what you get at a grand jury. If you're a prosecuting attorney, more than likely, you're going to get it. And that's exactly what happened in this particular case. And when he was actually officially indicted as a true bill, then he got ready to prepare for a jury trial. He was formally charged by the grand jury at that point, which was led by the state.
Thank you.
Yes, sir.
Yeah, we have another question from Chairman Smith.
He just answered mine. Thank you, sir.
And here we submitted the compensation package based on several factors. You got non-economic and economic losses, and we submitted through a certified public accountant, his firm, the economic losses that Mr. White would have occurred. That is typical on any civil personal injury cases, where you look at the loss of earning potential, and we actually took minimum wage that Mr. White could have been able to work in any job at age 19 to age of retirement. What's so interesting about this, that because he was not into the legal workforce, where's his Social Security? I mean, he's actually going to be a warden of the state either way you look at it. He does not have the tools, nor does he have the retirement fund through the Social Security or invest in the stocks or whatever to accumulate revenues to take care of himself. Now, we do know he made some personal choices, but the fact of the matter, when he was not allowed to work at a 19 or 20-year-old, I was able to go to college and go to law school with the grace of the Lord and my parents and my minister at the church. But once you're a registered sex offender, he was not eligible for college. He was not getting a scholarship. He was not eligible to go into the military. And I don't know what employer was going to take any reasonable risk to hire him for employment. And so that's why I think it's important, and this committee has an awesome opportunity here to not give him his freedom back, but to try to at least compensate him so he can live a dignified life the remainder of years that the Lord is going to allow him to be on the face of the earth. And this committee play a major role in that. That is an awesome responsibility, but also is an awesome opportunity for this committee to tell Mr. White, because he did not give up on a judicial system as an American citizen, then he can be somewhat compensated so he can live a dignified life. And we all are entitled to that as American citizens.
Let me ask you a question, if I may. He was convicted of rape wrongfully, but he did have a robbery charge, correct?
Yes, sir. Yes, sir.
All right, and the other one was aggravated assault. Is that a charge that was eliminated from the DNA test?
Yes, all those charges, the rape, the robbery, the aggravated assault, all those stem from that Mrs. Neely being raped. All that from the same case.
Okay.
So now when he was exonerated and given a non-pros, the state admitted, just like the gentleman explained to me, and I've been practicing for 18 years, that the state basically said that we made a mistake. We convinced the jury to convict the wrong person. It was not Mr. White.
Next question. He was convicted of 2 other crimes later, correct?
Subsequent to that, that is correct.
What were those again?
One was the cocaine charge, and that was in 1990. The first one was in 1992. It's here on page 94, and the other one was in 1997. Yes.
Okay. Of those 2 convictions, how much time did he actually serve on?
He
those?
served 2 with the cocaine charge, and in the robbery charge was 7 years. That's why when we did the calculation, it was actually 13 years and 3 months. They were actually incarcerated for the wrongful rape of wrongful conviction of Mrs. Neely. That was 13 years and 3 months. And before the Claim Advisory Board, the Secretary of State, she had calculated 10 years. But the record shows, and we submitted a proof from the clerk of the Superior Record of Marietta County stating that sentence of the robbery charge was done in December of 2005. He wasn't released until December 11, 2007. That's a 2-year period in which he was serving only on the wrongful conviction charge.
All right, on the ones he is guilty of, how many years did he actually serve on those?
A total of 9 altogether.
Total of 9 years?
Yes, sir.
Okay.
If you look at the 2 years for the cocaine and 7 years for the robbery. And actually, that was not like a robbery with a gun. It's like robbery by snatching. You have different kind of robberies. You know, some of I'm not trying to say what he did was not serious, because it was. But I just want the committee to know it wasn't armed robbery where he had a deadly weapon. It's like if you run up and snatch something, you call it robbery by snatching or robbery by intimidation. It's still robbery because you take something without permission of the rightful owner. But it wasn't anything armed robbery, anything of that degree.
Okay. Let me ask Mr. White, do you want to say anything? Would you like to come up? It'd probably be good if you would. And I got a few questions for you if I could.
And can I just say before Mr. White speaks?
Sure.
What kind of amazed me about Mr. White, he's very humble. He's God-fearing man. He's not bitter. My understanding, he had to attend his father's funeral while he was incarcerated for the wrongful conviction act.
Sure.
He had to attend his father's funeral in uniform. His mother, his sisters, they all have to deal with him being a rapist. And even now, most people, even now, they don't consider him innocent. They say, well, somehow that DNA was trickery. I don't believe in the science. So he still does not have the umbrella of the cloak of innocence like we have.
Sure.
He actually still is considered a rapist by most people, which is not true.
Will you let him talk,
Yes,
please?
sir.
Come on, how y'all doing?
Get closer to the microphone, if you will.
Okay. How y'all doing?
Fine. How you doing?
I'm good.
Good. Tell me something. What grade did you finish in school before you got your GED, before you went to prison wrongfully?
The 8th grade.
8th grade?
Yes, sir.
Okay. You were raised by a single mom, I guess, or did you have a dad as well?
Well, my mom, before I got locked up, my mom and dad, we lived, but my grandma raised.
Okay. You got any brothers and sisters?
I got 6 sisters.
6 sisters.
Yes, sir.
Okay. Interesting. Tell us more. Tell us about the prison time. You knew you were innocent, but you had to serve the time. How has that affected you on these other, once you got out, after you were paroled? Did that play into your other charges that you were convicted of or pled guilty of?
Well, when I went when I went to the penitentiary,
Where did you go? Tell me where you went.
when I left the county jail, I went to Diagnostics in Jackson, Georgia. You know, when I got there, you know, my people back then, they were poor. You know, she tried the best she could by hiring me an attorney, and it didn't work. You know, he didn't get me out, so I just accepted the fact, you know, that, you know, here I was, you know, and I just, you know, I just knew that, I knew that God knew that I didn't commit that crime. So I accepted. And I just went through it. I got out, and in 90, I had a hard time. You know, pretty much all my what is that, my childhood, where you normally adjust to, living, doing normal everyday things, I didn't experience none of that. So, when I got out, I had a hard time, and I got off in the drugs.
Yeah. So you couldn't find a job at that time, even though you learned a trade in prison, right?
Right.
A leather trade, I read.
Yes, sir.
Okay. What kind of leather was that?
Well, I make belts and pocketbooks and
Okay.
keychains and things of that nature.
That's good.
I did that, and I also did, work. I worked at this cabin place.
Okay.
Log cabin.
As a child growing up, were you sexually abused? Were you sexually abused as a child growing up?
No, sir.
Good. Okay.
I grew up a bunch of, I just said I got 6 sisters, and
Sure.
my grandma, I stayed with my grandma. I had much respect for them. My grandma taught me that.
Okay. Let me ask you this, and this is going to be putting you on the spot. Even though you served time and you were exonerated by DNA, but you were convicted of 2 other crimes, do you feel like you ought to pay the state back for the time that you served, those 9 years you served, that the state of Georgia had to pay for?
Do I feel like
You think you owe, if we compensate you now for the wrongful, don't you think we need to pay back from the compensation resolution? Don't you feel like you owe the state of Georgia back for what time you spent there? You earned your GED, which we're very thankful for.
I think while I was in the penitentiary, I served the Department of Corrections. I felt like that, each morning that I woke up and I seen a piece of paper that said, you got to report here, you got to report there. I reported and I did what was required of me. I worked hard. I respected everybody that I encountered. And actually, right now, I feel like no.
Okay. We have a question from Representative Lucas here.
Let me ask you something. Did you work on any road crews while you were incarcerated?
Yes, sir.
So you were outside the prison.
Yes, sir.
Did you work on any projects that might have involved the city or the state construction crews? Did you work on building any courthouses or doing any projects like that?
I worked on DOT. I worked outside the I worked on DOT most.
Mr. Chairman, I respectfully ask that. We really don't need to ask those questions. When you're working for the prison system, you're working for nothing anyway. And the state has gotten its use out of many prisoners, whether or not they've been incarcerated for various crimes or not. If they go outside the gates, then they work. Usually, it's according to a lot of crimes that they cannot even go outside the prison gate. They are considered too dangerous or might flee. So I would think we need to kind of get off that question. I think what we need to do is really look at what we have before us and make a decision on that.
Well, I'm here to represent the people of the state of Georgia, Representative Lucas, and I'm going to ask those questions.
So am I, Mr. Chairman.
Okay. You have that right, and I have the right too. Any other questions?
Mr. Chairman, can I just ask the committee to consider when we come up with these numbers in terms of compensation? We realize the state is in an economic crisis, And so we try to be very, very conservative. We gave you numbers just based on minimum wage. We didn't give any outrageous numbers, but clearly Mr. White, it would have had the opportunity to work more than one job, and he was just not given that opportunity as a young man. I was given the opportunity to go to college, and so were members here. That was taken away from him. So we would ask that the committee at least take under consideration that he was not allowed to build even on his Social Security fund, because he was not allowed to get a job after being labeled a sex offender of an elderly woman. There was no reasonable chance of employment. Even now, you can have a college degree, might have difficulties in getting employment. That's long been a registered sex offender in Georgia.
Okay. Got another question here from Chairman Smith.
Thank you, sir. In your notes, I guess it's starting on the third page of your handout, you alluded to two other people who have received compensation for their incarceration and once they were proven they were innocent. And you commented about Mr. Williams, and I remember that one because he served almost 22 years for a crime he didn't commit, and he got 1.2. Then down at the bottom of that same page, you're referencing Mr. Clark, who received $1.2 million for 24 years for a rape he did not commit, and you're asking for $2 million for 13 years, and that has been, less than a year, just a couple of years in time frame, as far as when the fees were paid. But you're looking at, 22 years, and one was 24 years versus 13.
Yes, sir, and I'm not aware of any. That is an interesting and a good point, and I pondered that prior to coming here. Where did I get my numbers from? And let me just say this: in all fairness to the other exonerees, the amount that they receive, I didn't have an opportunity to get an economist or a CPA to even calculate their loss of earning potential. So those numbers, and I'm quite sure they are grateful to any amount that the legislature voted to compensate them, and we'll be grateful as well. But we believe that those numbers were exceedingly low, because if you just look at Mr. White's loss of earnings at minimum wage, that's what we calculated. We meaning our CPA firm or an economist. This CPA firm have already testified as an expert witness in Muskogee County. So he has a master's degree from Tulane, and he gave us very conservative numbers to go before the committee. And those numbers alone, just his loss of economics, was over $1 million. So,
well, if you look at the
right.
$2 million that you're asking for, you'd have to make $100,000 a year for 10 years to make $1 million.
Yes, sir. The way we did that
and
calculation.
For $2 million, that means for the 20-year period, just on calculation of wages, like you were referring to, that would be $100,000 a year for 20 years.
No, so we did that calculation from the moment he was arrested to the moment that he would be eligible for Social Security. Because our premise is the fact that I don't know what employer in Manchester, in Georgia, is going to hire Mr. White in terms of employment. This young man, he want to work. He suffered some injuries in prison. His skills, his socialization process was actually severed. Being in prison for rape around other grown men that do things to people who are charged with these horrible crimes. So we believe that when we were able to go to college and to learn and to develop socialization skills, clearly Mr. White is handicapped in that department, being in prison for a crime he didn't commit. So what we asked the economist or the firm to do was calculate minimum wage from the time he was arrested and labeled a sex offender to the time that he would have been eligible for Social Security. Like, I'm going to be eligible for Social Security, but we believe that when he reaches the age of eligibility, he's not going to have anything in the fund because no one would hire him legally to work based on his prior wrongful conviction. And that's why we based that calculation on that, and not just 20 years, but we went from 1979, and we actually, in the document, you can see it's itemized year by year up until the time of Social Security, If you don't have it, I can publish it to you, because that was done we submitted that to the Claim Advisory Board, but I do have a copy, so you can follow my logic. If you would like for me to get that copy for you, we base that on the eligibility of Social Security, and which would have been around $80,000 that he's not going to be eligible for at this point of his life. I mean, he's just not hireable.
But isn't it instead of wages lost that you're trying to factor in here, isn't it the pain and suffering and the other items that you're trying to do? Because, there's an awful lot of people, and all you got to do is go by any school system in the state of Georgia, and you'll find there probably won't be a public school teacher there that makes $100,000.
Well, my main focus is to talk about the intangibles. I mean, loss of freedom. We know none of us can give Mr. White 13 years and 3 months of being in jail, in prison for a crime he didn't commit. So the loss of freedom, the loss of being with his wife, the loss of companionship, the loss of going to a church, the loss of being active in the community, those are what we call non-economic losses. Those amount, I can't even phantom, or I can't even imagine the amount that we can give him or any of the other exonerees for that concern in terms of a dollar amount. I just put emphasis on the economic, because those are tangibles that we can somehow, based on a formula, come up with a number. But in terms of being in jail and, he cannot even have, his legacy is over. My understanding, his lineage being the only son and only 6 sisters, his wife is past the childbearing age. I mean, even if he wanted to be a biological father, I mean, he cannot. So how do you put, amount on that?
I've got one other question for you, and Ms. Neely, was she ever had any compensation for the pain and suffering that she went through? Because she lost a lot of that same stuff as far as reputation, community, just because of being raped. Was she compensated in any way for the pain and suffering, and potentially, I know she was 74, potentially shorten her lifespan? I don't know.
I'm not aware of any compensation that she received, but I do agree with you completely that she was the one that was actually sustained the brunt of this atrocity that was committed by Mr. James Parham and not by Mr. White. But I have a mother-in-law. My mother's going to heaven, but I cannot even conceive any person being raped, let alone an elderly person in the twilight years of her life being taken advantage of, not only mentally, but more importantly, physically. So if she didn't get compensated, she should have, and I don't know of any mechanism, any type of agency that will compensate a victim. You do have what we call the victim impact, things that in Columbus, I can't speak for Manchester, but we do have agencies throughout the state of Georgia that try to give those persons counseling, if they need medical attention, which she did, give them free medical attention. She also probably was eligible for Medicare at the time. But I'm not sure any package or any formal compensation package that she received, to my knowledge. And
none of that would have paid for the pain and suffering?
No, sir. I mean, you cannot. You're correct. I mean, that you just cannot measure. How can you ever get over being violated physically? And so we can say the same for all rape victims, as well as those persons, whoever they are, that have been falsely accused.
One quick thing, and I'm going to hush. He didn't ask for this. He didn't ask to go to jail and serve all this time, but she didn't ask for it either, and she received nothing. And you're requesting $2 million. So I'll hush now.
Yes, sir. Mr. White would like to.
Excuse me, I would like to answer your question, if I could.
Get closer to the mic where we can all.
I feel like when she heard that jury come back with a verdict of guilty, I feel like Ms. Neely received the compensation she was after. I feel like she might have received some feeling of elation.
She didn't ask for that. She didn't need to receive that particular.
She received it through the judicial system.
You need to use the microphone, representing you.
Miss Neely was indeed a victim, and she had to live out the rest of her life knowing that she had been victimized. But the state of Georgia also created 2 victims in that courtroom. Not only was she a victim, so was Mr. White a victim. And his whole life has been overshadowed by what happened on that May 30th day in 1980 here in Manchester, Georgia. And as a state, we hold some responsibility. We hold some accountability to that. I don't even know if Ms. Neal is still alive, because we're talking about 30 years almost. But Mr. White is here. He's here and he's alive and he's standing right before you today, and his life has been affected dramatically, regardless of what all you say and what personal choices he's made. I never tried to present to you that he was a perfect man, but I did present to you that he was a man that this state owes some level of compensation. Now, we can argue about the compensation level, whatever this committee thinks is appropriate, we'll have to go with that. But the fact of the matter is, there were 2 victims that day. And one of them was 19 years old. And one of them is going to have to live the rest of his life with that hanging over his head. And when you think about it, the state of Georgia, what the state of Georgia did for him was put on him a scarlet letter. Y'all read the scarlet letter? They only put it on the woman, though, let me point that out. But he got the effect of having the scarlet letter put on him. Everywhere he has been since that time, he has been a convicted sexual offender in this state. And you and I know we don't like those people. We govern where they can live, where they can work, where they can go. We say they have to be on a public registry. So that, in my mind, is a traumatic experience for someone who was not guilty of that offense, particularly offense that was so terrible. I mean, you have to be a terrible person to break into a 74-year-old woman's house in the middle of the night and rape and assault and rob her.
Okay, we got a question from Representative Lucas.
Not a question, Mr. Chairman. I'd like to move.
Let me hold off on one thing. We got 2 other questions here. Chairman Williams.
I want to go back, and we're talking about compensation, and I certainly think that in this case there's some justification for doing that. But let me go back, and you're quoting 2 other convictions that have happened and the award that they got. These people served their whole time. They never got out on parole. Once they got out, they never had any other convictions at all. They lived a clean life. Yes, sir. Mr. White was paroled after serving 11 years, and I think that's something we ought to really consider, the fact that he was incarcerated wrongfully for that 11 years. But after that, he had an opportunity to make a living. May not have been the best living in the world, but had he been clean, he probably could have made a positive impact on society by getting a job and living clean. So I think that's something we also have to take in consideration, the fact that he did have that opportunity, but he chose to take the wrong path and jeopardize what we're talking about.
Yes, sir. And part of the committee, we respect that part of your analysis, and that just only being fair and reasonable and looking at the totality of the circumstances. But the total amount of years was 13 years and 3 months that he served specifically and only under the wrongful conviction case. It was 13 years and 3 months. But we do agree with part of your analysis that he did serve some time outside of that wrongful conviction. But we are going to argue, if you're a registered sex offender in Manchester, Georgia, with no socialization skill and no reasonable chance of employment, that your fate was sealed. He was not eligible for the military. He couldn't go to college. He couldn't get a scholarship. We believe that no one in their right mind, and being an employer, was going to hire Mr. White when they had other opportunities to hire residents of Manchester with no record. So why hire a sex offender? That's exactly what he was faced with, and that was his reality, for better or for worse.
Well, he was able to get his GED, and I commend him for
Yes,
that.
sir.
But he just made some bad choices.
Okay. Representative Lemore James.
Thank you, Chairman Williams, for softening up just a little bit there. But I tell you, I'm 71 years old. And
Representative James, will you pull the mic in front of you when we hear you?
First, I said I thank Chairman Williams for softening up just a little bit there. But I'm 71 years old. And not just $3 million, but for $30 million, I wouldn't want to spend the rest of my life in jail for it. So we got to look at all of these kinds of things. I can remember when I was in the 7th grade, I was told by my 7th grade teacher said that none of you, talking to her class, accumulatively in a lifetime will not make $100,000. She was wrong. I overcame that figure years and years and years and years and years ago. The potential of this young man, we don't know, had this not happened to him. We got to take all that into consideration too. The young lady that was victimized, God knows the person that did it. If you gave him the death penalty, I wouldn't feel sorry for him. We are here to talk about Mr. White and what has been done to him. And I think we should be fair and we should be equitable about doing that, Mr. Chairman. How can we put a dollar figure of one's life that has been tarnished for the rest of his life? If he lived to get 90 years old, he will never be able to go out in the workforce out there and get a decent job. Even if he had an education, even if he had a doctorate degree, he still would be penalized when he go out in the workforce to try and get a job out there. These things should be considered as well. I'm so glad the DNA was finally discovered, so we won't be doing these kind of things in the future. But it's painful. It's real painful to stay incarcerated for any length of time for something that you did not do. And I don't think that we should hold back on compensating people that have been exonerated for being falsely accused. And I think the one that we've done in the past, I think we was unjust to them. But that's not the case here now. It's Mr. White. And I hope that we'll consider being fair and just in what we do for Mr. White here today.
Okay. Chairman Parsons, point of clarification, last 4 years you chaired this committee. We did annuities, isn't that correct?
That is correct, yes.
Okay. The Claims Advisory Board here is recommending $54,000 for each year the claimant was wrongfully incarcerated. Have you always followed that procedure, Advisory Board?
No, I believe we've changed them before. I think we've changed
Okay.
the advisory.
How about if in this case, Mr. White, if he were to do another crime, what happens to the compensation annuity? Does he lose it?
I don't. Honestly, I can't tell you, Chairman.
Okay.
I don't know what
There's
we're
always been a clause that it's based on no future conditions.
Okay. So there is a clause put in there. Okay, Representative Lucas.
Mr. Chairman, the figure in this particular resolution, the compensation board recommended it.
No, sir. The information I have, they're recommending $54,000 each year for the claimant for 10 years, so it amounts to $540,000 total. That's up to this committee now to
Mr. Chairman, I would suggest that economic times and what the dollar's worth, there's a big difference. We did not have that big downturn in the economy when we did that made the other compensations. The other thing I say, I chaired state institutions and property, and I had a chance to travel this state. And one of the problems for any person coming out of prison, the first thing on that application, have you ever made a felon, been convicted of a felony? It has a tremendous effect on whether or not a person can get a job. Now, here recently, the federal government put monies in that if a person had been in prison and someone would take a chance on hiring them, even cleaning up, janitorial, and there might have been a fiduciary responsibility and something missing, that the feds, through the Labor Department, put up the money to guarantee the bond so that particular person could work, which many of us didn't even know anything about until somebody presented to us. I would like to suggest that we amend the amount on line 24 to 1.5 and then pass this resolution out of here.
Okay. 1.5 on line 24 from $2 million to $1.5 million. You putting that in form of a motion?
I will put it in a form of a motion if I can get a second.
Do I hear a second? All right, got a motion and a second. Any further discussion?
I'd
Go
like
ahead.
to discuss. I guess Representative Lucas, and I have a tremendous amount of respect for you, but how are you coming up with that figure?
Well, basically, I'm basing it on today's economy, and I'm not an economist, but the dollar's less now than it's ever been in the history of this country. And if you add, if you take the figures, and you looked at what we did in the past on the others, the 24 and the 22, we were not at the same juncture as we are today about the dollar that we are today. And I just assume just out of looking at what the dollar is worth. I mean, it's not worth what we always think it would be. But by that and looking at what we did with those that served 24 and 22 years, I make that motion that we reduce it to 1.5.
Chairman Scott, do you have any further discussion?
Well, I'm sorry, and I apologize that I wasn't. I was in another committee meeting.
Let me, while
trying
you're
to make sure
looking,
I'm right
let me
here
do
in that-
this. Chairman Williams has a question while you're
Okay.
looking.
Mr. Chairman, I'd like to make a substitute motion.
What motion would that be?
We go back to the compensation committee on the notes under the attorney gave us. The 13 years, the 54,000, the 13 years, and it came out to $709,090. I'd like to make that recommendation.
Okay. We got a motion on the substitute to amend it from 1.5 to $540,000. Is there a second?
709.
Excuse me, $709,000. Is there a second? Okay. Discussion. Okay.
Mr.
Chairman
Chairman,
Scott.
and again, I'm trying to catch up from being out. But this is, when was the conviction? 1980. I'm sorry?
Chairman Scott, look at that. Let me go to Chairman Parsons.
Thank you, Chairman. On this motion we have now, and I think that would take precedence, so I don't think we can change that particular motion. And I appreciate I appreciate what Chairman Williams is trying to do. Here again, having chaired this subcommittee over the previous 4 years, and the only thing that's happened economically during the last 4 years is it's a lot harder to get money. That money means more to us now than it did 4 years ago. These have just been relatively these awards we've made over the last few years have just occurred over the last few years, and they were for longer convictions, and we gave less money than what Chairman Lucas had actually suggested. And I would just submit that I think for this particular, although I believe he deserves something, I believe even the $700,000 is way too much. That's just my opinion. I'm just suggesting that. So I just believe that since this amendment that's been proposed is too high, the only way I could support it would be if it were amended, if that amendment were to be amended to make it a much lower figure, if that were actually adopted and that took the resolution, and that's what we had to vote on at that time.
Okay, let me go back to Chairman Scott here.
Thank you, Mr. Chairman. I guess as I do this, the original conviction was about 1980. Is that about the time that? Okay, we've got a 20-year sentence, then we've got a 2.5-year sentence, and then we've got a 7-year sentence. That's 29.5 years. If the sentence had been served, I mean, he would just now be getting out of prison. So,
If you would, use the microphone, if you would, Representative Huey.
The burglary charge, what you're looking at as the 20 years, if Mr. White had only been charged with burglary as a 19-year-old without any prior experience with the law, he would not have gotten 20 years. All of these charges were ran at the same time. And you know, when they take you to jail, when they take you into court, they put everything up there and see what all sticks. That's how we do it. And that's what happened in this case. And the prior testimony was that from Attorney Dowdell, who used to be a DA, assistant DA, was that for a person of his age without any prior history, he would probably have gotten probation. At most, he would have gotten 3 years. He would not have gotten 20 years for that offense. And that was what you missed when you were not here.
But
That's what we talked about.
this was a robbery. Was it an armed robbery?
No, it was a burglary, not an armed robbery. The robbery was...
Well, it says robbery.
Those
It
are
says
the wrong
burglary on one side. It says
right, the
robbery on
burglary.
the other.
What I can help for your edification, if you look at attachment 4, it shows James Parham, who was also sentenced for the same charge of the independent charge of burglary. Mr. James Parham, and I submitted to you on attachment 4. That's relevant because what we're trying to do is speculate to what would have happened to Mr. White absent the wrongful conviction and just standing the burglary charge alone. What would have happened, he probably would have given a sentence of probation. And I will have asked you or to publish you attachment 4, which shows a person that was in the same county charged with the same crime of burglary and pleaded guilty with a long criminal record. That person only received 3 years. Mr. White at that time didn't have any criminal record. His record was clean. He had no record at all. So that burglary charge probably would have yielded probation. So he was wrongfully incarcerated, not 10 years, but based on the documents from the official record of Manchester clerk office, it was 13 years and 3 months. And if you make that comparison with the last compensation package, that amount would be $728,244 that we really disagree on because that just takes under consideration his economic losses. That does not take into consideration loss of liberty, loss of life, loss of being able to rear a family, being assaulted, and etc. We believe those other cases, and we're very grateful to the state that the other exonerees received compensation. But we believe that based on economic and non-economic losses, those compensation was inadequate. But this committee now has a great opportunity to not right a wrong because we can't undo or give him his liberty back, but at least give him dignity. I mean, as an American citizen that been wrongfully incarcerated by the state through the district attorney's office, the GBI, as well as the local Manchester Police Department, that his compensation, at least let it be, something that's dignified, that he can has a reasonable chance at living a decent life.
Can I ask a question?
Yeah.
You're an attorney, correct?
I am for almost 18
Okay.
years.
Did a jury of 12 people hand down the conviction?
Yes, sir, based on the prosecution of the state.
Who's the defense attorney?
The state. The defense attorney was Sanford Bishop. He's the U.S. representative. At that time, he was the
I know Sanford
defense
well.
attorney.
I actually like him. I guess my question is if and I would say this regardless, I like
Right, I understand.
Congressman Bishop represents my area. I think he's done as a conservative Republican, he's done about as good a job as I think as we would expect. I'd remember the other party. Why shouldn't the defense legal counsel be responsible through malpractice claims and other claims for the charge? If it was a doctor, I mean, you would go to the doctor.
Right. But a defense attorney, what I would argue, I would ask you, if you look at the chronology, you have very specific dates. One date being the September 20, 1979, when when Mr. White was put in a lineup. We believe that defense attorney, Sanford Bishop, may have anything to do with the police department, Manchester, the GBI, as well as the district attorney office. They orchestrated and they developed that lineup process. That lineup process was flawed. The person who actually committed was in the same lineup. But for, we believe, the suggestive type measures, giving the victim pictures of the driver's license of Mr. White, was not done by his attorney, but was done by agents of the state. So the agents of the state propel this before a grand jury, got a true bill of indictment. Thereafter, a couple of months later, got a jury to convict the wrong man. And the state thereafter submitted a null process, which they admitted that he should not have been prosecuted. So the null process was the Latin term, meaning not to prosecute. But that was after the fact. That was after he served 13 years and 3 months just for the wrongful conviction alone. And that didn't have anything to do with the defense attorney. The defense attorney actually was defending Mr. White very aggressively that he was innocent. And Mr. White always maintained his innocence. He didn't have to plead guilty and then recant. He maintained his innocence before all these agencies from the moment he was actually inquired about whether or not he had anything to do with Mrs. Neely or rape.
Representative Lucas?
Mr. Chairman, the reason I brought the 1.5, I mean, let's look at it. No Social Security. He probably going to have a problem getting health insurance. You know, I mean, all the various tests and stuff, you know, and we've had problems even with folks in prison coming out with different hepatitis and those kind of things. But to me, to be incarcerated, period, is frightening. Because I've been incarcerated, but it was for voter registration. But to be incarcerated for a crime that you didn't commit, and I don't know how many of y'all ever been to prisons. I've been to every prison in this state. You'll be surprised at the kind of things that you have to do to even exist. I mean, you get I forget what they call disciplinary actions, just for defending yourself. No wrong, but if you don't defend yourself, you will get shown up misused. And it's just hard in prison. I don't know how many folks have been. I've been in them. I've been to Jackson. I've been on death row. I've been to all those places. It's something that if you've never been and you serve in this General Assembly, you ought to go just one time so you can understand the kind of atmosphere that's in there. Again, I say to you, I looked at the two, but I looked at what we did for the previous two. And what we did for the previous two, the dollar was not what it's worth today. And in all the things that we are doing, and especially trying to get somebody to get their life back together on the right track, at the same time, you still have a problem, job employment. That thing goes with your rest of your life when people say, well, that's the guy that was convicted of raping a 70-some-odd-year-old woman. You've been exonerated, but guess what? There's still that atmosphere out there, and there's still those folks out there that don't want to believe it, period. It makes it hard to get a job. The other thing is, if you look at what do you do and where you are in life, and we know he doesn't have enough quarters to get Social Security. That's the first thing you got to have. So I think when you look at the overall picture and the overall scheme of things, I don't think any amount of money can compensate you for the time you lost. But I still recommend to you reducing it to 1.5 on today's economy scale. I think is appropriate compensation.
Okay. Representative James.
Representative Lucas has addressed the things I wanted to, except we should not look at the economic downturn and say we shouldn't give a certain amount because of the economic downturn, because the injury has been there, and we should look at the injury and not the economic downturn.
Okay. Representative Hughley, do you want to say anything else before we call for the vote? A few closing remarks.
Yes, and I would like for you to allow Mr. Dowdell that same opportunity. Let me just say,
he'll be out of order.
Okay.
You're in order, but
All
he'll
right.
be out of order.
well, let me just say to you that we have a responsibility as a state to do justice in this case. This young man, as every citizen, places our trust in our justice system. And when our justice system fails, we have the responsibility to make amends. Mr. White was just saying to me that he goes to therapy every week, even now, through the Georgia Innocence Project. And his life has been affected. And his life is going to continue to be affected. And as I said earlier, there were 2 victims in that courtroom that day. One is no longer with us, and one is yet alive and has to live out the rest of his life. He and I are about the same age, and I plan to live a long time. and he has a long time yet to live. And we're all concerned about our futures. When we look at the stock market and what is going on, we're concerned about our future nest egg. And think about the people who have no nest egg. My last thing to you is that, except by the grace of God, this could have happened to any of us.
True.
And where would we be if our name was tagged with being a sexual offender? What would our life be? And that's what we have to think about as well. We can't get so high that we don't think about the fact that only the grace of God separates us. And that's what has separated us in this instance. And I would urge you to do as much as you can on this particular case. My preference, of course, would be for you to go with Mr. Lucas's suggestion. But I understand we are a deliberative body. We are the sum total of our life experiences. And fortunately, many of us have never had the experience that Mr. White has had. And I would not wish his experience on anybody that I know. But we are where we are, and we have to make a decision. And I'm trusting that we, in our collective wisdom, will make a decision that's going to be fair.
Okay. Thank you for those comments. Now we're in a posture. We have a motion of compensating $1.5 million, and we got a substitute motion to compensate him for $709,000. We'll vote on the substitute motion of $709,000. All in favor, say aye. Let's vote. Let's vote. Hand vote. All those in favor, raise their right hand for the $709,000. Okay. All those opposed to the $709,000, raise your right hand. Well, no. Okay. Okay. The motion is we amend the HR 161 to $709,000 in lieu of $2 million and the 1.5. Any other changes we need to make on the resolution at this time? Any other amendments? Yes, sir, Chairman Parson.
I'm trying to think procedurally. Was that amendment adopted? The substitute amendment?
It was.
Okay. So can we further amend the amount?
I'm sorry, what?
Can we further amend the amount?
I don't think we're in that posture now.
So.
Okay. The vote was what?
There's 4 against and 4 in favor.
Oh my goodness. 4 and 4. I voted. So we're in a posture now where the whole resolution is going to fail. Okay. Use your microphone there.
Mr. Chairman, I would suggest you call for a vote again.
Okay. All those in favor. Wait a minute. Get your light.
And this may be out of order, but I'm sorry if there's a wrongful conviction, but as I look at this timeline, there's less than a 3-year period where there hasn't been another conviction for a crime. Am I correct in that? That there's a release of 1990, then there's another crime, arrest and conviction in 93. You're released in 90. There's another conviction in 93. You would then have been released in, depending on the timeline, 95 or 96. There's another conviction in 97. Am I correct on that?
Yes, sir. And we were dealing with the numbers that, based on the prior case of Mr. Williams that was exoneree, we looked at those. You have what we call a compensation comparison calculation. And this young man spent I know what you're saying based on this other prior didn't have anything to do with the wrongful incarceration. But I would just ask you to consider in your analysis, he was still wrongfully incarcerated for 13 years and 3 months. And based on that per month, compared to the 2007, he should be compensated $728,244,000. We argue that just economic loss, and not loss of his freedom.
It was a sentence to run concurrent with another sentence, though. No. Is that not correct?
Right. He was sentenced to life plus 40, and the burglary charge of 20 years ran concurrently, which means it ran simultaneously
I
at the same
understand
time.
what it means.
So he was actually serving jail time for the wrongful conviction of 13 years and 3 months. I mean, we got document from the clerk record, certified copies to substantiate that argument, that he received jail time for being wrongfully incarcerated. I don't understand your question.
Yes, you do. You're a good
What
lawyer.
is-
You argue your point, but I
Okay.
mean, you understand my point.
Yes, sir, that he also was convicted of 2 other charges. They have anything to do with the
3.
wrongful. No, it was just 2, sir.
He's
It
got
was
the burglary,
No.
which was running concurrent. There's a burglary that was to run. Is that correct? There was a burglary that was to run concurrent,
Mhm.
which means simultaneous with the charges that you're talking about compensating for.
Mhm.
Right.
Yes, sir.
And then he was paroled, and then 3 years later, there was he was paroled in 1990. In 1993, there's arrest for possession of cocaine, which led to another 2.5-year sentence. And then, so depending on the timeline, he would have been released after the 2-year sentence and then convicted of robbery again in 1997
Yes,
with
sir.
a 7-year sentence.
Yes, sir. Mr. Sanford Bishop advised him when he was sentenced under Judge Jackson to 40+ life to plead guilty to the burglary charge because it ran simultaneously, concurrently. And that would have been the same advice I would have given him. You just been levied life plus 40. So you can add 10 other charges. As long as it didn't run consecutively, why not plead guilty to it and let it run concurrently? You already sentenced to life plus 40. And that's exactly what he did on the advice of his attorney, Sanford Bishop, at the time. That's exactly what Mr. White did.
Representative Lucas needs to.
Don't need anything but call the question, Mr. Chairman.
All right, the question is, we had a motion to do $1.5 million, and now we have a substitute motion for $709,000. And Chairman Scott, do you have another question?
I'd like to make a further substitute motion that the bill move to the advisory board's recommendation. The bill, this $54,000.
$540,000.
That I would recommend that we take an amount no higher than what the advisory board
Okay.
recommended.
All right, we got a motion, 1.5. We got a substitute for $709,000. Now we got a substitute for $540,000. I don't think I called for the question.
Okay.
Okay.
If that's the recommendation, if that is that recommendation from the commission, then I'll withdraw my.
Okay, thank you. Okay, the motion is $709,000, correct? Okay. All those in favor raise their hand. All those opposed raise their hand.
Mr. Chairman, I'm going to abstain. I'm opposed to the resolution.
Okay.
Period.
Thank you. Okay, HR 161 as amended, substitute HR 161 as amended to, what was the number, 709,000? Okay, and $90. All those in favor, raise their right hand. All those opposed, raise their right hand. 2 opposed. Okay. What was the final count? 7 for the original. Okay. Okay. All right. HR 161 will be passed on to the full Appropriations Committee. Thank you for your time. Thank you.
Thank you.